كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provides a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Good afternoon, everybody. So it's my pleasure, first of all, to welcome you to what I believe is the 37th seminar in phase 4 of the International Interdisciplinary PhDs in Progress weekly seminar series, which has been organised by the Global South Network. So before I begin, I should thank Dr. Nouman Rayat, who is the lecturer in law at Leicester Law School, and the founder and the chief convener of the Global South Network, who has taken main responsibility for organising and leading the series. Having said that, I'm now going to make a few introductions, if I may. So firstly, I should probably introduce myself. I'm Justin Jones. I'm Associate Professor in the Study of Religion at the Faculty of Theology and Religion at Oxford, and I'm acting as chair for today's session. Just as a bit of background, I've long specialised in Islam in South Asia. A lot of my earlier work was on Shia Islam in North India in particular. In more recent years, I've been working much more on a series of issues relating to Islamic family law and so-called Muslim personal law in India. So I've worked on issues such as India's legal, sort of pluralist legal framework in personal laws, and particularly Muslim personal laws. And I've worked to a strong degree on women's rights in particular, and I'm now doing work as well on Islamic family law and children's rights. Hence my interest in some of the themes that we will be touching on today. Next, I should introduce our discussant for today's session, Dr. Amra Bone, who I had the pleasure of working with on a project a few years ago. So it's nice to see Amra here again. Dr. Amra Bone is a research fellow at the Ibn Rushd Center of Excellence for Islamic Research. She's also a scholar and a community leader with expertise across Islamic studies, interfaith engagement, and Muslim family law in the British context. She holds a PhD from the University of Birmingham on the subject of Quranic exegesis and the interaction between religious sciences and the rational sciences. And her research and writings have addressed themes including Islamic marriage and divorce in the UK, Muslim women's leadership, and historical debates on freedom of expression in South Asia. She's also been a founding member of the UK Board of Sharia Councils in 2012 and served as a member of the Birmingham City Council Trojan Horse Review Board in 2014, as well as serving on the National Muslim Women's Advisory Group and the Faith Leaders Training Review Panel at the Department for Communities and Local Government in 2010. I would also like to introduce our peer commentator, Martin Stenfors Eidrup. Please forgive any pronunciation errors that I'm sure I'm making while I introduce you, Martin. Martin is a PhD. Martin is a PhD student in religious studies with a focus on the study of Islam at the Department of Literature, History of and Religion. This project started in 2023 and seeks to study how Muslims in Sweden and Belgium interpret and relate to Islamic family law, for example, in rules around marriage, divorce, and inheritance. Martin has previously worked for, among others, the Swedish Migration Agency, the Ministry of Foreign Affairs, and the Swedish Civil Contingency Agency, both in Sweden and in other countries in the Middle East. As a doctoral student, Martin is a member of a national graduate school in Islamic studies, which is funded by the Swedish Research Council and coordinated by Linnaeus University. And then finally, last but not least, I should probably introduce our actual speaker for today's session, Ummul Fayiza, who is an early career fellow at the Institute of Advanced Studies at the University of Warwick. So the title of Fayiza's PhD, recently passed during a viva, was Destitute Muslim Women and Muslim Personal Law Reform in Post-Colonial India, a critical analysis of Muslim women's rights discourse in the light of Shah Bano and Shahida Bano cases. Her research critically examines legal reforms concerning Muslim women's rights to maintenance and divorce within the legal plural context of post-colonial South Asia. As mentioned, congratulations to Fayiza for passing her PhD, I believe 2 days ago at Warwick Law School. Now, of course, this in theory is a PhDs in Progress seminar, but I'm assured not only that we very much want to hear Fayiza's work, but also that as we all know, the work continues to be work in progress even after a PhD viva, and therefore Fayiza is looking forward to the feedback that we may be able to provide. So thank you very much in advance to Fayiza for her presentation. Today she will be presenting part of her PhD project entitled Constructing Destitute Muslim Women, Criminal Law Reform, Colonialism and the Limits of Unifying Post-Divorce Maintenance Rights. So Fayiza, if it's okay, we'll suggest around 30 to 35 minutes for your presentation. That will be followed by 5 to 10 minutes dedicated to comments and questions from our discussant. And any time remaining, I can take questions from the floor, of which I'm sure there will be plenty, and we'll be done by 4 o'clock, hopefully. So Fayiza, the screen is yours.
Good evening, everyone. Thank you, Nauman and the Global South Network team for giving me this opportunity to present my research. And I'm excited to present this, and I look forward to receiving your feedback, which will be very helpful as I work toward the publications. So my PhD research analyzes in broad 3 major legal reform efforts and 2 landmark judicial interventions in post-colonial India to assess how these reforms have engaged with Muslim women's agency and Muslim women's rights. It explores how these representations of Muslim women's agency have shaped the directions and limits of legal reform concerning Muslim women's rights. So by focusing on the symbolic and politically charged issues of triple talaq and post-divorce maintenance, my research reveals the interplay between political and judicial domains in shaping Muslim women's agency and rights. Central to this discourse is the recurring depiction of Muslim women as destitute under Muslim personal law, a portrayal that renders them dependent on state intervention or legislative reform due to the perceived failure of intra-community support structures. So today I'll be presenting the first chapter of my research. In this chapter, I examine how the narrative of the destitute Muslim women emerged in post-independence India within the context of secular reformist and development interventionist state approach to reform Muslim family law. This narrative was shaped through the unification of post-divorce maintenance, specifically by amending Section 488 of the Colonial Criminal Procedure Code of 1898 and enacting Section 125 of the Criminal Procedure Code 1973. I argue that this construction of Muslim women's agency centering destitution developed by transposition of colonial legal gendered economic category of destitution into the post-colonial minority Muslim family law context. Furthermore, I show the extent to which this narrative featured in the legislative debates and feminist responses surrounding the criminal law amendment, while also highlighting the limitations of such narratives in advancing Muslim women's rights. So first, I would like to provide some background on what constitutes Muslim family law in general and Muslim family law in particular in Indian context. The presence of religious family laws in India has historically been a site of contestation, intersecting with debates on gender, community, secularism, religion, nationalism, and minority rights since the colonial period. So religious personal law was established under a British colonial regime through the codification of Hindu and Muslim family laws, thereby reconfiguring the colonial legal order in which family matters were governed according to religious norms. Following independence, the Indian Constitution recognized religious family laws under its broader accommodation of religious and cultural diversity, extending legal recognition to the family laws of Christian, Jewish, and Parsi religious communities. These laws govern the personal matters that is central to religious and community life and identity, including marriage, divorce, inheritance, maintenance, guardianship, child custody, and adoption. In addition to religious personal laws, several customary laws and tribal laws are recognized in India. Furthermore, the Goan state has its own unified system of civil laws. Despite this legal pluralism, there are optional civil laws that allows individuals to opt out of religious personal laws, particularly in matters of marriage, divorce, and maintenance. This is important for those who do not want to be governed by religious family law. Nonetheless, the Indian Constitution also articulates, always politically contentious, of course, aspiration to unify these diverse personal laws through the implementation of Uniform Civil Code as envisioned in Article 44 of Indian Constitution. So Uniform Civil Code aimed at regulating personal matters irrespective of religious affiliation remains deeply contentious issue. This aspiration for Uniform Civil Code has been visible from battles over post-colonial constitutional settlement to the recent attempt by state government of Uttarakhand. So in general, religious family laws have often been critiqued as being oppressive to women, particularly due to the public-private divide wherein patriarchal religious authorities exercise control over family matters. Predominantly, secular feminist scholars and other reformists argued that religious governance of family law is antithetical to women's rights and advocate for liberating personal laws from religious authority through the state intervention. Although these critiques apply broadly to religious personal laws, Muslim personal law has drawn particular scrutiny because of its uncodified nature and the communities resistant to state intervention. So there are various perspectives and approaches towards this existence of religious family law in India. For instance, Matthew John argues that the defense of family personal laws by Muslim representatives during the Constituent Assembly debates and subsequent decades has contributed to the communalization of Indian citizenship, undermining the ideal of liberal citizenship. Similarly, Robina Robinson, Archana Parasha, they all argued that state has prioritized protecting the rights of Muslim minorities over women's rights, thereby perpetuating unequal citizenship between men and women. Also, there is Vrinda Narayan's work, which highlights the structural inequality within family law, particularly between Muslim women and women from other communities. So at present, there are 4 main statutes formally govern the Muslim family law in India. Alongside these, several informal extrajudicial or parallel adjudication systems also exist, predominantly overseen by religious authorities. In addition, alternative forums such as women's Sharia courts have emerged, challenging the predominance of male-centric Sharia courts. So today's presentation will take you back to the debates of 1970s in India, which centered on securing post-divorce maintenance rights to the amendment of Section 488 of colonial criminal law. Okay, so the unification of post-divorce maintenance through the 1973 criminal law amendment and the concurrent construction of the narrative destitute Muslim women emerged from two interrelated factors. First, unlike other communities' religious laws, Muslim family law lacked codified provisions governing maintenance and post-divorce maintenance rights for Muslim wives. Second, Muslim women who attempted to claim maintenance under the colonial criminal law often faced challenges of being unilaterally and instantaneously divorced by their husbands through triple talaq. This tactic was frequently used to avoid maintenance obligation, as divorce legally released Muslim husbands from responsibility under Hanafi interpretation of Muslim family law. So in the context of Muslim personal law in the 1970s, the uncodified nature of Muslim personal law Shariat Application Act 1937 and the lack of explicit maintenance provisions in the Dissolution of Muslim Marriages Act 1939 meant that Muslim women often faced legal and practical barriers in securing maintenance during and after marriage. So that's important. Whenever a Muslim wife, as a wife, they approach to the court for maintenance from the husband under the colonial criminal law, husband used this triple talaq. They pronounce the triple talaq to divorce them, so that they don't be obliged to maintain the wife, because now they are divorced, they are no longer the wife, and they can easily get rid of that maintenance responsibility. So Muslim women have this dilemma in which, as a wife, they don't get maintenance because when they ask for maintenance, they get divorced. So post-divorce maintenance, there is no such provision according to Muslim minority position. There was no such provision existed under the Hanafi legal position. So unlike many in other communities who were required to follow legal procedures to divorce their wife, Muslim women face particular disadvantage due to the practice of unilateral and extrajudicial divorce and instantaneous divorce. This asymmetry made it significantly easier for Muslim men to avoid legal obligations such as maintenance, especially when faced with claims under the Section 488 of the Criminal Procedure Code. So the understanding was that once a marriage is dissolved, the husband is not obliged to provide maintenance beyond deferred mahar. There is this, Muslim women are eligible to claim deferred mahar or the idda period maintenance, but after that, they don't need to provide anything. So this concept was derived from the Hanafi legal principles. So the absence of legal regulation concerning the amount of mahar, which was often nominal, further exacerbated the vulnerability of divorced Muslim women. Moreover, the ability of Muslim men to remarry or practice polygamy without ensuring financial stability for their existing wives underscored the limitation of legal protections under Muslim family law. So Flavia Agnes highlights this position of Muslim women, Muslim men as a double-edged weapon for Muslim husbands. This inadequate protection offered by Muslim family law in this context contributed significantly to the push for amending criminal law in 1973. So this precarious situation, which leaves divorced Muslim women without adequate financial security, was identified as early as 1958 by activist lawyer Dania Latifi. Latifi later gained prominence for representing Shah Banu in the landmark 1985 case, which again generated a controversy over Muslim women's rights and minority rights in India. So Latifi highlighted that the judiciary has often been perceived as powerless to address the issue, particularly due to the constitutional protection of Muslim family law. For instance, the primary barrier for the judicial interpretations of Muslim family law was the legal precedent from the colonial times. These legal precedents granted legitimacy to the unilateral divorce and restricted the judge's authority of interpreting Muslim family law. This limitations has been a source of contention as it limits interpretative flexibility within Islamic law in India. So Latifi argued that imposing financial liability on irresponsible Muslim husband could curtail exploitative practices and provide essential support to divorced women. He also advocated addressing post-divorce maintenance through secular legal framework rather than relying on solely religious law. Such an approach, Latifi suggested, would bypass the influence of religious authorities and their governance of cultural practices. So the criminal law amendment were the result of the combined efforts of Latifi and Justice Krishna Iyer. Latifi, through his civil society activism, championed the cause, while Justice Krishna Iyer, in his capacity as a judicial member of the Law Commission, used his position to advocate for this reform. While sharing his experience as trial court lawyer in Malabar, Justice Krishna Iyer remarked that I had seen, while a trial court lawyer in Malabar, how young castaway women with crying babies in arms came to the court, seeking help, except for Allah, only to return home weeping. So you can read this quote from the Justice Krishna Iyer. So Iyer highlighted the plight of Muslim women left destitute due to the practices of unilateral divorce and polygamy. He was particularly critical of the judiciary's reluctance to creatively interpret existing laws in ways that could provide redress to these women, arguing that judges often cited legislative inadequacy as a reason for non-intervention. For instance, on maintenance claims by Muslim women, 2 Kerala High Court judgments illustrate the contrasting judicial approaches, even though both acknowledge the hardship faced by destitute Muslim wives. So in Yusuf Rautar and Saurama, in his capacity as the presiding judge, Justice Krishna Iyer adopted a reformist stance, advocating for a compassionate interpretation of Islamic personal law that prioritized the protection of vulnerable groups, particularly women, and granted maintenance to Muslim women. So in contrast, the subsequent ruling in Muhammad Hanifa and Patuma Bibi made by Justice Khalid reflected a more restrained approach. While expressing sympathy for the financial precarity of Muslim women subjected to unilateral divorce, the court declined to grant maintenance beyond the iddah period on the grounds that such provision was not recognized under Muslim family law. Justice Khalid lamented the judiciary's inability to intervene, citing the binding nature of legal precedents and the policy of non-interference of Muslim family law. To address these gaps, the amendments of Criminal Procedure Code in 1973 introduced with the aim of providing greater financial security to women. It was Section 125, it was introduced. So Justice Krishna Iyer reflected on his tenure with the Law Commission, recounted that he recommended the expanding the definition of wife to include the divorced women. So in the colonial criminal law, it was the maintenance was provided for the wife, children and parents. But in this amendment, they included the provision for the divorced wife, so that it would be extended to women from divorced women, and as well as women from all communities. So this reform, he emphasized, aimed to salvage women in distress and prevent them from being left destitute. So it was the 6th Law Commission that proposed the inclusion of divorced women unable to support themselves as eligible claimants for maintenance from their former husbands. A central aspect of this secular project was the construction of the destitute Muslim women and the advocacy for the criminal law amendments as a solution. Unlike religious family laws, criminal laws apply uniformly to all citizens, transcending the religious distinction, and are thus viewed as a step toward a common code. However, this approach has some limitation. Firstly, the legal framework for addressing destitution remained deeply rooted in colonial legal structures, which carried gendered meanings articulated through the unequal power dynamics between the colonizer and the colonized. Despite claims of, even though in the Law Commission, they mentioned that it is the socialist kind of intervention, that is what they are doing, and the intention to provide for those in need, the law did not adequately question the placement of civil matters within the criminal law. Instead, it justified this by positioning it as distinct from religious family law. Notably, judges and lawmakers often quoted British lawmaker James Stephen in their discussions of maintenance rights without critically engaging with the socio-political and colonial context. Secondly, the Law Commission's approach also drew upon moral anxieties, expanding the definition of social evil to encompass vagrancy and also the concern about prostitution. So if women doesn't have enough maintenance or survive, then they will go to the prostitution. So those kind of moral anxieties were also visible in this document. The law thus framed maintenance as a preventive measure, reflecting broader anxieties and social order and the moral integrity of family structures. Thirdly, the Law Commission applied the same logic regarding vagrancy and maintenance to both parents and wives. So there is also inconsistency in a way they have applied this. So this framing was less concerned with gender equality than with the socialist goal of, again, preventing vagrancy. So as a result, the Law Commission's approach reinforced the idea of the heterosexual family as a political institution without significantly challenging the underlying gender dynamics. Rather than addressing these through the state responsibility of welfare, it shifted this responsibility into the male breadwinner, adhering to colonial governance. However, this attempt at reform was ultimately subverted in the parliament as legislators considered to demands from sections of the Muslim community to accommodate religious differences. So the debate surrounding the issue gained greater momentum when it reached the Indian Parliament, revealing the diverse and often conflicting positions within the post-colonial Indian society. Unlike the constraints faced by the judiciary, the legislative domain was viewed as a space to transcend the existing boundaries set by the legal precedents, particularly those that address the emerging issues of destitute Muslim women. Compared to the secular position and the modernist socialist language of the Law Commission, the state has introduced the amendment through the development interventionist state approach. It is important to distinguish India's interventionist and developmental state model from the welfare state model prevalent in the West. Unlike the race-based framework typical of the welfare state, India adopted a need-based interventionist approach. It is mainly, I drew this from Nirija Gopal Jayal's work. So this model focuses on fulfilling state obligations by addressing perceived needs of the marginalized communities. Initially, the Indira Gandhi-led Congress government justified the need for unifying post-divorce maintenance rights as a humanitarian concern, emphasizing the economic challenges faced by destitute divorced women. By presenting the reform as a humanitarian measure, the law minister sought to distance the state intervention from family law, positioning it as a complementary to Muslim family law rather than a contradictory. This approach, centered on destitute Muslim women, failed to see how Muslim women navigate between gender and religious identities. Secondly, this approach uncritically accepted the colonial criminal law, again overlooking its gendered underpinnings. In pursuit of development goals, the post-colonial state presented itself as a universal class, claiming to act in the interest of the nation while safeguarding the private interest of the state. So, however, this statist and secularist intervention faced significant opposition from Muslim minority community, which claimed for the non-interference in Muslim family law. This position rejected reforms that sought to alter maintenance arrangements prescribed in Muslim family law. So mainly there are three primary arguments put forth by the Muslim minority leaders. Firstly, they contended that a divorced wife does not legally qualify as a wife under Muslim family law. They demanded an exception for Muslim from this position. And also, secondly, they elaborated that maintenance for a divorced wife is restricted to 3-month iddah period or until the end of pregnancy for expectant mothers. They opposed the provision which mandated monthly maintenance payment beyond this period. So thirdly, the argument centered on the double benefits that Muslim women perpetually received under Muslim family law. So they argued that if a divorced Muslim woman is entitled to deferred mahar, which would be sufficient. So if giving more than that would be a double benefit for Muslim women. So their arrangements primarily focused on procedural aspect of Muslim family law, predominantly following the Hanafi legal principle, which lacked provisions for post-divorce maintenance. They did not engage with the critical question raised by the Law Commission regarding the responsibility of the divorced husbands toward impoverished former wives. Instead, they believe Muslim women have adequate protection within Muslim family law. This approach failed to address the ploy of Muslim husbands unilaterally divorcing their wife when asked for the maintenance. The secular stand here in the Parliament, they argued that Section 125 of the Criminal Procedure Code does not conflict with family law. There is no conflict, rather that aligns with the Quranic principles. So they emphasize that inadequacy of customary law and personal law in safeguarding women's financial security was a recurring concern. So, for example, one of the parliament member, Vyas, relying on customary practices, posed a significant, he argued that it is a significant threat to women's rights. So, despite the discussion on destitution of Muslim women and making Muslim men responsible, a section of Hindu male parliamentarians, they talked about unburdening men from maintenance responsibility in different contexts. So these arguments were not really centered on Muslim women, but they argued that it is a burden that man providing the maintenance to divorced wife, children, and parents. So it's a burden for men. So yeah, we can see this difference, how when maintenance is talked in terms of Muslim men, it's always kind of formulated in terms of responsibility. But when it comes to Hindu male, they always talk in terms of a burden. So this difference we can see in the parliamentary debates. So finally, in the Indian state conceded to the Muslim minority claim for non-interference, and they included a section 127(3)(b) in the 1973 criminal law, and argued that it exempts if you have claimed any in terms of meher or any customary law. If any Muslim women have claimed anything, even if it is a meager sum, they won't be eligible to claim post-divorce maintenance. Again, when looking at the parliamentary debates, we can see that what is absent there is all men, reformist men and Muslim men, is talking about Muslim women's rights. And despite the diverse position articulated for or against this unification of post-divorce maintenance rights for destitute divorcees, women's voices were largely absent from the debate, with the notable exception of there is this Temur Begum Jahan's petition was submitted in the Indian Parliament. So that was the only Muslim women voice, or even the women's voice, that I could find in the legal archive. So this absence reflects the overwhelmingly male-dominated nature of the discourse surrounding post-divorce maintenance rights, which overlook the gendered implications of the criminal law amendment. So one of the major legal feminist engagements, other than that, so coming again, I'm taking you back from the parliament. One of the major legal feminist engagement in the 1970s was reflected in Towards Equality report, which addressed the various socio-economic and political issues faced by women in India, including the specific challenges women encountered under different religious legal systems. So a report supported the unification of post-divorce maintenance through criminal law amendment, as it would provide a more accessible and efficient legal remedy. However, the report criticized the use of concepts like chastity, which restricted Hindu wives' maintenance claims, as a past conduct or allegations of adultery could disqualify them from receiving maintenance under criminal law. It also criticized this financial ceiling of 500 rupees for all dependents as being inadequate. Report further recommended the economically independent women should bear financial responsibility for their children. So there is a approach of formal equality where women should also be responsible for that if they are capable enough. So, however, the report failed to critically engage with the state's approach of imposing uniform solutions on women from diverse cultural and social backgrounds, thereby neglecting to acknowledge the legal pluralism, including the specific concept of contractual or deferred mahr, what that constitutes for Muslim women, or is there a mechanism to develop that as a legal framework for Muslim women to secure financial security without interfering with the Muslim family law, but rather than incorporating what are the principles available in Islamic law to engage with that. Furthermore, they refrained from interrogating the underlying colonial logic. But again, they also framed this concept of destitution as if there is no such provision, it would lead to a crime like prostitution, etc. Even in the feminist approach that time was similar to the law commissions and colonial logic. So in contrast to the liberal feminist approach, it was Flavia Agnes who broadly questioned the maintenance legislation and its implication for women's economic subordination. She argued that the meager dole guaranteed by the state was insufficient to support women and children. So that was the second position. She upheld that she argued that there should be a differential treatment for women and men. So this is different from what gender equality approach of the liberal feminist. So while Agnes recognized the need for maintenance for divorced women and the economic disparities between men and women, she failed to acknowledge the diverse experiences of women across different community. I know that this position of Agnes has changed now, but yeah, it was during the 1970s debate, it was her response. So she did not consider how maintenance issues might be perceived by minority Muslim women, and moreover perpetuated stereotypes about Muslim women, such as their alleged oppression due to the practices like parda, illiteracy, and polygamy. So these different feminist approaches demonstrate that dominant feminist perspective often viewed Muslim women through the lens of secularism, development, and modernization. Consequently, they endorse state-initiated secular reforms as a solution to end the perceived oppression and destitute Muslim women. Although these perspectives recognize the gender differences between men and women, they fail to extend their frameworks to address the specific issues faced by diverse women in this context, particularly Muslim women and their intersectional lives shaped by factors such as culture, religion, and minority status. The only positive outcome of this deliberation was the movement of Muslim women's maintenance claim from the extrajudicial realm of Muslim family law to the formal legal sphere. So that created opening for Muslim women to contest maintenance claims through the court system. So that is how then led to the famous Shabanu case. So here in this debate, we can't see any particular women's figure as, destitute Muslim women, but there are many legal cases has been implied in this context. But later then, Shabanu's become the symbol of this, emblematic of all destitute Muslim women in India. So thank you. I'm looking forward to your comments.
Thank you very much to our speaker for a very rich and very interesting presentation. To keep time, we'll just move straight over to our discussants, if we may, to get their comments. So maybe if we could start with, I believe Dr. Bone might wish to add some reflections. Thank you.
Assalamu alaikum. Thank you very much, Fayiza, for your Ummul Fayiza, sorry, for your very interesting presentation. I have a number of comments and some questions for you. The situation is very interesting in India, and it's a kind of dynamic one. For that, on the one hand, you have a Muslim personal law. On the other hand, you have the civil courts, but the conflicts that I'm seeing, it seems to me that there are a lot of parallels with what I do here in the Sharia Council, and we have the civil courts, and then there's the Sharia councils. Muslims approach Sharia councils because they want to do the right thing in the sight of God, but yet they also want to have their rights not be taken away from them, because the Sharia councils don't have any arm of the law, whereas it seems that you in India do have the arm of the law behind the Muslim personal law. Am I correct in saying that? So the
yes,
yeah, okay. So so if they are to actually access their rights through the Muslim personal law, then they are prohibited to go to the secular courts. Is that, am I correct in saying that, or please explain?
So Muslim women can access both. Like it's up to the Muslim women whether they want to go to the court or whether they want to the Sharia. But at the same time, as I mentioned, like formal legal system is very limited in a way. How much that can give to the, how much or for what Muslim women can approach the court is very limited. So most of the things are done through the Sharia courts. Yeah.
Right. Okay. So the interesting thing is that while Muslims would come to the Sharia councils here in Britain to try and sort of dissolve their marriage. But if they have any disputes of financial nature, which they're not willing to resolve within the Sharia council, then they will approach, and in fact we encourage them to approach the family courts to decide on their financial affairs. So to a degree they can get the best of both worlds, because the limitations of the Sharia councils can't, are not able to give them their financial rights, but yet the family courts can. So another point that you made was about the Sharia Muslim personal law. The Sharia courts are not codified, and hence that leaves women more vulnerable. But I mean, does it not equally then suggest that they can be also equally more sort of benefiting, in the sense that they, since it's not codified, there is the ability to actually understand the situation of women and live according to your sort of times, as in not. If they were codified, then it would be hard in that sense. However, if they're not codified, then the Quranic principles can sort of come into play, as in, to sort of treat women on equitable grounds, live with them in harmony, and release them with goodness, which is ihsan. And so all those principles can be more likely to come into play, I would think, which I mean, you didn't really speak too much about that. So I just want to highlight that the Hanafi principles compared to the other Sunni schools tend to be kind of more so on taking that the Quran as a precedent, as the utmost precedent to a degree compared to the other schools. And the Quran has verses such as Amr bil Ma'ruf wa Nahy anil Munkar, which means to encourage good. Ma'ruf is not just good, it's also what's known to be good, what's customarily right and just. So the way the women should be treated would, my understanding would be, from a Hanafi perspective, that should be taking into account how our modern understanding of what is customarily good should be applied to women equally as is to men. So do you want to say anything about that?
Thank you. So in Indian context, it's a little bit different from like what you have in the UK. Because, for example, nikah, Muslim nikah is not valid if you go to the formal legal system in the UK, but in India it's valid. And also there are, because today I talked about the 1970s context, it has changed now. So now Muslim women can claim post-divorce maintenance in a different way. We have a famous, after Shabanu, we have this in 2001, Daniel Athrifi judgment that is kind of articulated Muslim women's post-divorce maintenance in a very women-centric perspective, where without kind of interfering with the Hanafi legal principle. So which stated that Muslim men are obliged to provide a lump sum settlement as part of the divorce. So, but they can provide it during the iddah period. So, it is a very progressive and in a way very differently interpreted without conflicting Muslim family law and the criminal law. So now Muslim women in India have a choice to claim maintenance either through the Muslim Women Act that has been enacted in 1986 or the criminal law. So we have both options now in India. So that is one thing that I want to say. And regarding the triple talaq, now it has been criminalized, but then I discussed that in my final chapter. Its issue, one of the issues is that it doesn't take into consideration of these legal precedents. For example, it nowhere mentions about this maintenance claims or the dower or any Islamic legal principles, but rather it kind of, first of all, it criminalizes a civil matter, but second, it doesn't take into consideration of any Islamic legal principles that is available for women. For example, it only mentioned that there should be a subsequent allowance, rather than saying there is a meher or is there anything Muslim women can recourse to. It also silent about, yes, it is now criminalized, but for a believing Muslim woman, she doesn't know the status. Am I divorced or am I still a wife? So these were not again.
So that dynamic of criminalizing it, and majority of the women, like the activist Muslim women as well, were saying that they wanted the reform from within Muslim personal law rather than going to outside of it. And so this kind of tension that the secular courts are criminalizing something that's religious, which kind of not really understood. But if you may be aware that now in many parts, particularly in Southasia, in Pakistan, and I'm not sure too much about India, but they are a huge number of prominent scholars, well, if not huge, but at least a number of prominent scholars have actually said that the 3 talaqs in one sitting is to be recognized as 1 talaq, which, as you know, already has been a principle among the Ahl Hadith and some other schools. So it was not something that perhaps needed to be criminalized, because the actual debate had been there since the time of Ibn Taymiyyah, and whose opinions have sort of have been taken by so many scholars from different schools of thought. So it's just I mean, according to Agnes, as you mentioned, she said that she didn't like the way that the whole debate was done about Muslim women, because Muslim women are actually kind of not oppressed, but it's the way the whole debate took place. And she was highlighting how Hindu women suffer so much and commit suicides, etc. And so there was a lot of politics involved there as well. In the whole debate. So I'd say thank you very much for your response, but yeah, and I think there's a lot that can be said, but I think I know limited with time.
Thank you.
Thank you very much. Maybe we'll ask Martin to make any comments he may wish to make, and then we might have some more time afterwards.
Excellent, thank you very much. And thank you, Ummul Fayiza, and also congratulations, of course, for your successful defense of your PhD dissertation. I have 2 questions, or maybe 3, depending on the time. Because I'll just start with the first one. Because I always find it quite interesting to look at how legal changes may be sort of influential for the construction of a public narrative, regardless of the actual legal or political result. So what I mean is that even failed reforms or discarded reforms may contribute, I think, in powerful ways to the construction of a truth or an image. And in this case, that would be the image of the destitute Muslim woman. So I wanted to ask whether you think that is the same that is happening, sort of reflecting of the legal and political history that you have analyzed too. So to what extent is the image of the destitute Muslim woman sort of independent or dependent on the success or failure of these specific reforms? Was it, for instance, more forceful when legal changes were successful, or rather when they were abandoned or scrapped, because then the perceived problem, so to speak, would still persist? That's my first question.
Thank you. That's a very interesting question. So I have to say, I have analyzed the 3 legal reforms. So that is so far we have in India regarding the Muslim family law. So first one is 1970s, and second one is 1986, and third one is the recent triple talaq criminalization in 2019. So all of these parliamentary debates and this legislations that I have analyzed, I could see that it was the interest of the male, either it is, secular reformist male. In the case of 1970s, that was proposed, but it was failed because of the prioritization of Muslim minority male interest. Again, in the 1986, it was a Muslim minority male interest that was, succeeded. But at the same time, in 2019, it was more or less political Hindu right-wing instrumentalization of Muslim women's rights that has been happened. So all of these cases, because of this, they are ignoring the intersectional positionality of Muslim women. They either prioritize women's rights or prioritize the minority rights. So that is what's happening in all of this context. But at the same time, as I mentioned, even though there is a failure, but there are some positive outcomes in a way how it has been evolved in later years. As I mentioned, in the case of 1970s, it was failed, but later judicial interventions of Justice Krishna Iyer in Bai Daira and Fizlambi cases that has actually positively interpreted it to grant maintenance to positive was maintenance to Muslim women. But later, then in Shah Banu, it became, problematic because of the judge's proposition of, implementing uniform civil code and some of the problematic comments on Islam. So that is how this whole issue started in 1985. Before that, many Muslim women claimed actually maintenance, positive was maintenance, even though that was the 1973 amendment was included the Muslim minority aspiration. And again, when it comes to 1986 Act that was enacted to limit Muslim husbands' obligations towards the post-divorce maintenance, limiting to 3-month iddah period after divorce. But later on in Daniel Latifi judgment, again, that kind of granted Muslim women's rights. So it is quite complicated in a way how it was started and how it is Muslim women were able to claim the maintenance in actual times. But again, what it shows that in 1986 or even the Daniel Latifi judgment, there is this absence of engagement with unilateral divorce at that time itself. If they would have engaged with that question at that time itself, it would have changed the scenario in India. You don't need this whole last 30 decades, thinking about or engaging with the triple talaq, because 1970s itself, they have recognized it was the unilateral divorce that was the core issue of this. Even a Muslim wife cannot claim the maintenance. So that is what I'm trying to say. They are not looking at this intersectional positionality of Muslim women and leaving out the core issues and talking about something, something else. That is. That's why in my thesis, I kind of argue that there is this limitation of legal reforms that has been initiated and broadly discussed by, male leaders in both contexts. Thank you.
Thank you. Martin, did you have another follow-up to that? Because I'm quite keen to take some questions from the room as well. So did you have another question you wanted to ask?
I have another question, but it's not a direct...
Go for one more, and after that, I'll take some questions from others attending.
Okay, I'll try to be quick. Thank you, Ummul Fayiza. You also mentioned that in your talk that the sums of deferred mahr were often very low, nominal sums, right? And this, I guess, was another aspect of the problem that was kind of identified in the debate, because it would mean that there was no protection at all for divorced women. Was this? I was curious about the sort of relationship between these two questions, the question of maintenance, post-divorce maintenance, and the question of deferred mahr. Was this also recognized by the lawgivers sort of in the political debates, or was there ever a debate over changing any law that would affect mahr rather than the laws on maintenance?
So yes, in the case of Justice Krishna Iyer's judgment in Bahitaira and Fazlumbi, what he argued that he considered the meher, how much was given to the parties. So he said that it was not sufficient. That is why now they have to, grant the post-divorce maintenance under the criminal law. So if it was not sufficient under Muslim family law, then the criminal law applies. So that is Justice Krishna Iyer position. And many progressive judges afterwards kind of engaged with that and considered that in the formal legal system. Yes, of course. But at the same time, we don't have any, legal statute or anything that prescribe that, meher should be this or anything that consider that. There has been many Muslim women's rights organizations arguing for there should be a proper kind of codification of Muslim family law that states that at least the annual income of the Muslim husband should be given as a, meher. So, but that is not in practice. It's a different story.
Thank you.
Thank you. I'm happy to take questions from others. So if anyone has any questions, please put your team's hands up. And I'll do my best to take any. Rashida Abdul Hamid, I can see a hand. So yes, please feel free to speak.
Hello, and thank you, Ummul Fayiza, for a very interesting presentation. My question is about what you referred to as the judicial policy of non-interference. And I was wondering, because since Krishna Iyer made that comment, a few decades have passed, and I was wondering if that is still an entrenched judicial policy, and amidst this, against the backdrop of increasing calls for the Uniform Civil Code. Thank you.
Justin, may I add to this thing, because my question is sort of connected to this one. I think a lot of non-interference policy from the judiciary usually has to do with the potential reaction from the clergy. So I wonder if you could shed some light on the reaction from the clergy to these decisions, judgment, observation, because most of the time judges hesitate, the superior court judges, to make any decision or policy decision because they think that they need some help with regard to the interpretation of religious texts. Yeah, please.
Okay, thank you very much for both questions. So regarding the policy of non-interference, it was actually legal precedent we still have is Narasu Appamali from 1954. So even recent Sharabanu case doesn't really change that legal precedent. It's still valid. So that is one of the judicial domain that is still prominent. So non-interference on Muslim family law. So second thing regarding the reaction of the clergy, I would say that it varies. It's not the same actually, because when I check the clergy's reaction to the Justice Krishna Iyer's judgment, it was not very much controversial. And even the Dania Latifi judgment, they didn't really react. They didn't challenge it. So that is one side, but at the same time, when it comes to Shabanu and many other cases, Sharabanu, as we have seen recently, there is a way in which how they engage it. For example, even in the Shabanu case, they are not engaging with the actual issue of the triple talaq and Muslim women not getting the rights. Rather, they said that the Quranic principle, the Quranic verse, that's from chapter 2 to 26 verse, I think, yeah. So they said that is only applicable to really pious and religious Muslim men, to oblige to provide for the other non-practicing or not pious man, that is not actually applicable. So these kind of very narrow-minded approach is another problem we have regarding like how Muslim personal law is not progressed so far. And even regarding the Sharabanu case, initially triple talaq was actually endorsed by the All India Muslim Personal Law Board, but later they again said that it is not we don't entertain, and we will publicize the notice not to practice. So that is the kind of, there is a difference, of course. And again, I'm coming from southern Kerala, where we follow Shafi legal tradition. So I have seen Muslim leaders have a very different approach in the South when it comes to post-divorce menace. They are okay with it. So there are different diverse reaction even within the Indian context, how they approach the Muslim family law reform. And again, another example is Tahir Mahmood. So he has wonderfully engaged. His intellectual tradition is very important in regarding Muslim family law reform. But at the same time, when it comes to the politically contested debates, even Dr. Tahir Mahmood during the before Shabanu case, he was in a way supporting the uniform civil code, but at the same and the codification of Muslim family law. But after in response to the Shabanu judgment, he removed the chapter supporting the Uniform Civil Code from his book in response to the protesting against the judgment. So we can see the political context can change the positions the different scholars take. That is another scenario that we have to look at. Thank you.
Thank you. That seems like a fairly fitting note at which to close. If anyone's got a very quick question, I can maybe squeeze in one more, but I'm aware that I'm going to start to go over time if I do this.
I have a very quick one.
Okay, quick one.
It was about the women's Sharia course that you mentioned that they have established. How have they been received by people at large or the Muslim community? And are also the Muslim Personal Law Board, are they willing to take on women to, enhance their board? Could you just give us a comment on that, please?
Yeah, of course, there is a change in All India Muslim Personal Law Board, and now we see some, even though nominal, there are some members in the All India Muslim Personal Law Board. But women's Sharia courts are not really recognized or, supported by the All India Muslim Personal Law Board or other religious scholars. But we can say there is also Tamil Nadu Muslim Women's Jamaat. These are like different Muslim women's organization that is setting up this women's Sharia court, challenging this male-dominated Sharia courts. That has been, there is an increasing recipients from the Muslim community now, but again, largely they were not really welcomed in the I would say the public, but there is some change, but not very much. They have their own challenges in tackling these issues. I think Justin is working on that, so maybe he can give some other. Thank you.
I have done, but I'm doing my job as chair and keeping my own mouth shut. So, but I think nevertheless, I probably need to bring this to a close because we've already run over. So, if I may, I'll just end up with a few thanks. So, thanks first and foremost to Faiza for such an interesting and insightful presentation, and congratulations on the Viva. And we look forward to seeing the so-called work in progress coming into publication very soon. So thank you. Thank you also to Dr. Bone and to Martin for their comments, and to everyone for attending the session. Global South Network warmly welcomes PhD students from any discipline in any part of the world to share their projects and gain interdisciplinary feedback. So anyone who is interested in presenting their work at such a forum can contact Dr. Noman Rayat, the founder and the convener of the Global South Network, at the email provided in the chat box. So same time next week for the next session. Our next guest speaker will be Anushka Chaudhary from the School of Sociology, Politics and International Studies at the University of Bristol, who'll be presenting their PhD project entitled Intergenerational and Transnational Bengali Cultural Identity Migration and Long-Distance Nationalism in Britain. On the 24th of September, same place, same time, so 3 o'clock UK time. Thank you very much. Look after yourselves, and I'm sure we'll see some of you next week. Goodbye for now.
Thank you.
Thank you.
Thank you. Thank you, everyone.